Hello, everybody.
Hello? I'm on mute. Can you hear me?
Yes.
Okay, are they dismissing everything or do I still have the review cases?
Just 1 second, sir. Mr. Evans, just 1 second. We're in the middle of something. The evaluator did opine that he should be evaluated by a DCR prior to release. And the court is adopting that, indicating they should be held until no later than noon on the 25th for that purpose. And that is, he was
So we got RV.
unable to proceed under both prongs. Mr. Mercer, does he have a history of one or more violent acts?
I don't know that we have out-of-state history on him.
Okay. And all I see here is the.
Was I found competent or incompetent?
No, Mr. Evans, we're not, this is someone else. Now we're about to address your here.
Is it standard?
Okay. And this is City versus Sylvester Evans.
It's Andrews that showing the blue line.
082019.
Everybody can come out.
5525 3A0549215 4A0231898 4A04725552 and 3A0312319. Have the parties had an opportunity to review the evaluation?
Yes.
Yes.
Did either party take exception to the court adopting?
Okay.
I have an objection.
All right, so we're
Object to the court adopting the evaluation?
What's the status of the evaluation? Was it competent or incompetent?
I'm not able to proceed.
So that mean they found me incompetent?
Yes.
Okay, could I see the paperwork on that so I can review it and have that challenged?
So just to be clear, if you're incompetent, everything gets dismissed. If you're competent, then everything proceeds.
So that's what I'm asking. Did the doctor find me competent or incompetent?
Incompetent.
Okay, under what circumstances? What was his reasoning?
Delusional thinking.
And what proof did he have on that?
I mean, the interview that he did with you.
Okay, and being that you said everything is dismissed due to delusional thinking by law, from what I read at the law library, it said being delusional in itself is not reason in itself to be declared incompetent.
That you are unable to assist in your own defense because of it. So there are two prongs, there are two ways that you can find someone unable to proceed, that they don't understand the nature of the proceedings, which you clearly do, and the evaluator said that. But that you were unable to assist in your own defense due to the delusional thinking.
Well, that's being with the letter that I sent to you, that would directly refute that, correct?
No, that supports that.
What the letter I sent to you, it had motions that I wanted filed and whatnot that would prove that I'm able to assist in my defense, correct?
No, it was, you wouldn't give me any information. You gave me half information about things, refused to give the further information when I asked in court.
I did declare that the information regarding the evidence, that was a matter of secret state privilege. And then I also declared that the motions that I want to file, I didn't have access to the law library to get the proper documentations.
I am adopting the evaluation over your objection, and finding that you are unable to proceed in these matters. So the pretrial cases are dismissed. All of the reviews are closed pending a further finding of able to proceed. The evaluator did not opine that you should be evaluated by DCR prior to release, so you're just released today. You can appeal this. You're welcome to appeal this finding, this ruling, and you could come to the court and the clerks can tell you how to do that, what paperwork to file.
All right, so I'll be released from jail today.
Correct.
And also, can I get the paperwork of the evaluation from the doctor?
You represent yourself, so I think you kind of have a right to it.
Yeah, how do I get that paperwork?
Mr. Ionati, are we able to print that out for him?
We can print it off and give it to the officers to give to them.
Okay, we'll get that to you today.
Okay.
All right, thank you, Mr. Evans.
And
Just-
also, I want to put on record that I want to file a notice to appeal to the Supreme Court of the state of Washington.
That's appeals from courts of limited jurisdiction go to King County Superior Court.
But you want to appeal the fact that all charges are being dismissed? That's what you want to appeal?
I understand that, but I want to bypass the superior courts and go directly to the Supreme Court due to the circumstances and the nature of the judgment.
Okay, you can try to do that.
I want it on record noted if you
No,
have a,
you have to actually file it. That means nothing. You have to actually file the documentation. You have to file notice.
that's impossible to do from in here. You're saying when I get out, I have to file it?
Yes, correct. You'll have 30 days to file it.
Okay.
Okay. You should know, though, that you are still trespassed from the airport. Nothing in what I've done today affects that. That is the airport's trespass notice. It is still fully valid. You will be rearrested. Okay?
So even if I'm there on personal travel, I'll be rearrested.
You have to comply with their rules and restrictions. I'm not going to give you legal advice as to what that constitutes, because you need to look at your trespass notice. But
Yeah, I was there this time on legal business.
we're done. We're done with this case. This case is dismissed. So we don't owe me any explanations. I'm just telling you that the trespass order from the airport is still out there. Okay? I'm just letting you know.
Okay, so I can still be arrested under false premises, because they also said I confessed in this case, which was not true.
I am just telling you that the trespass order is still there. That's all
Okay.
I'm telling you. Okay, thank you, sir.
Okay. Also, what I want to fire Mr. Ionetti as
He
well.
doesn't represent you. We've already gone through that. He doesn't represent you. You can't.
Okay, well, is he going to give me the paperwork that I need for these proceedings?
Score will.
Okay, and the evaluation as well from the doctor?
Yes, I believe we'll be printing that out. Mr. Ionati said he would print that out for you.
Okay.
All right, thank you, sir.
Oh, what is going on with the review cases? I guess I haven't
They're all
heard that part.
closed. They're all closed, pending a further finding of able to proceed. If maybe.
Closed. What does that mean?
It means there are no affirmative conditions or no conditions can be imposed because there's a finding of unable to proceed.
So they can be reopened later.
They can.
So I can have a warrant placed and I don't even know it once again.
Well, no, you would have to get notice of a hearing.
Like this time, I didn't get notice of the review hearing and they placed the warrant out for failure to appear. I didn't even know I had a hearing on the review charges.
Okay. This is why it's very important to keep your address updated.
My address is very, I don't know, for lack of a better word, I do a lot of moving around, so I don't have a steady address that I can always get mail at the moment. So that's how we got in this position the first time.
Well, so that sounds like, I mean, if you're not going to let us know how to get in touch with you, then you can't complain when you don't get notice.
I can give you an email. Would you be able to contact me by email?
And I think we have that listed.
But they never gave me a notice of any hearing via email.
Okay. We will make a note, email only.
And I'm still confused as well. The case is open or closed?
Closed. He's unable to proceed.
And I'm confused by that. So the conditions were imposed. There's an allegation that he violated him. He's not found competent. We can't move forward in those violations, but it doesn't invalidate the conditions that were set because those were done at a time that he was competent. Like, is the court still taking jurisdiction? Like, I'm still struggling with that.
I can't impose conditions.
The conditions were already imposed, though.
I know, and they're stayed. Everything is stayed.
Sure.
Like-
But so the case is open but stayed, or is
I
it
guess
closed?
that's maybe a better way to characterize it, but it's for all intents and purposes closed, effectively, pending a further finding of able to proceed.
And also, would I be able to subpoena any grand jury proceedings that may have taken place as well?
There are no grand juries in courts of limited jurisdiction, and I don't believe there are in Washington at all, other than federal.
Okay, okay. And so you said, yeah, I'll get a copy of the evaluation, and you say I got 30 days to start filing motions to try to get everything reversed, right?
At this point, your only avenue is appeal.
Correct.
Okay. All right. Thank you, sir.
So I think the city is objecting to them being closed in any way.
So they're not closed. They're just, I mean, I thought we talked about this.
I know, but when we're using words like closed, is there gonna be a CL for
No.
closed disposition?
No.
Because that's what's gonna be in the docket is they're closed. And so in a year or two, if this comes up again, it's gonna be very difficult to figure out what exactly happened today if we're
Well, in
using.
2 years, it's too late. Jurisdictions run.
Sure, there's some situations where that wouldn't be the case, but so the cases are open is all I'm trying to understand.
Yes, they are not closed. They're just,
Okay.
Okay, so would you be able to clarify that for me, Miss Your Honor, in layman terms, so I can get an understanding, because you said it's not closed, but it's open closed, which is kind of difficult for me to
and
understand.
I am, you guys are right. I should use more careful language. The cases are open. They are stayed, which means frozen, essentially. Unless there's a further finding by a doctor that you are able to proceed.
Would that be able to be done in the appellate courts or the state Supreme Court, or overturning his findings, or what? How do you get the proceedings to be found? How do you get that overwritten?
Basically, if you leave it alone right now and just stay crazy, you'll never have to worry about it again. But if you appeal it, and if you're later found competent, all of these charges, boom, can come right back on ya. Silly subsidiary.
Basically, what the doctor prescribed or diagnosed.
So, and this is interesting. It's a situation I haven't come across where there's an individual wanting to contest the finding.
Yeah, based on, I don't have the law library's information in front of me, but based on the information I got from the law library, a defendant cannot be declared incompetent by being delusional in itself.
And
That's
I explained to you what the evaluator opined, that your delusion is impeding your ability to assist in your own defense. That's what the evaluator, am I characterizing that correctly, Mr. Mercer, Mr. Ainati? That's what it sounded like to me.
In what way though? How is it impeding?
You're asserting defenses that don't exist.
Such as?
The stuff about the case in Louisiana.
That you're royalty?
I asserted evidence that has a seal on it. So the only way he can find out that it doesn't, what I'm saying is not true, is to get the seal broken on the evidence, which is under state secret privilege. And the only way you can get that broken is by orders of the president or Chief Justice Roberts of the United States Supreme Court.
So when you get all your ducks in a row to get that happening so that the court can see it, it sounds very far-fetched. I've never heard of anything similar happening on a state case that the U.S. Supreme Court would involve themselves, much less that any one justice would have authority to unseal something. I'm adopting this finding. You can appeal.
Is everything that we spoke about today on the record? Would I be able to get recordings of all the subpoena recordings of all the hearings, including what we're talking about today?
They are all online, available for you to listen to anytime you want.
Okay, and they all can be subpoenaed by the state Supreme Court and whatnot to be overturned or sealed. Also,
they are not going to do any investigation on your behalf. If you're appealing, you have to do all the investigation.
Right. No, I don't need them to do the investigation. Everything's pretty much said and done. The only thing is the assumption that you guys don't believe the evidence is under state secret privilege, and I am who I'm telling you I am. So you're
Okay.
believing I'm delusional. Am I correct?
That's correct.
Right. So y'all making assumptions that's not true, that I have to go through the process and get everything removed to the federal courts to prove that it's true, which is going to be under seal at that moment. But I give the state Supreme Court a chance to make the adjustments and
Okay.
override.
Okay, thank you, Mr. Evans. You'll be released today and you can get working on all that. All right, thank you, sir.
All right. So we're done here.
We're done here.
Appreciate it.
Not to beat a dead horse, but could the order be worded a little bit differently for the review cases?
Okay, yes.
I'm just anticipating a year from now, we're all going to be possibly confused, including myself, on what exactly is the status of the cases. That's all. I'm not trying to be difficult.
No, I appreciate it actually, given everything that's happening. Okay, I think that is more accurate than I added cases. These cases are reviews and are stayed pending a further finding of competence.
Okay.
That's more accurate, right?
I appreciate that. Thank you.
It looks like Mr. Matchet's refusing to get out of his bunk. I'm right at his door right now.
Mr. Matchet, would you like to join us for court today?
Yes. Hello.
Hi. Can you
How you
please
doing?
sit up? We can't see you. All right, thank you, Mr. Matchet. I appreciate that. Go ahead with the arraignment.
This is case numbers 3A0253564, 3A0341886, 3A0492049, 3A0645558, 3A0821562, 4A0305203, all on for arraignment, and then there's for review, and then the 4A0472554 is on for arraignment. And is Thackeray Javon Matchet your true and correct name?
Yes.
And your date of birth is October 4th, 1980?
Yes.
Earlier today, we discussed your rights at arraignment. Any questions about your rights that I wasn't able to answer?
Yes.
Do you have questions about your rights at arraignment?
Yes.
Then we can go into a breakout room and discuss those rights. Give me 1 second. And Mr. Matchet, did you have any questions about your rights at arraignment? And Your Honor, I've gone over the charge, the maximum penalty, and the mandatory minimum penalty. We'd acknowledge to the complaint, wait for reading, ask to enter plea of not guilty, and we are asking for direct appointment.
Plea of not guilty will enter. I do find probable cause to detain and it will direct appoint. What is the city's recommendation regarding release?
City seeking bail in the amount of $500 on the new case. He's on sentencing conditions out of this court for law-abiding behavior, not going back to the airport. Both of those have allegedly been violated with the court's probable cause finding in this case. He also has an active warrant out of the Tacoma Municipal Court, warrant history, and 80 to 90% of the criminal charges in jabs currently. So for those reasons, I don't think that he's going to appear or abide by court conditions in this case.
Any objection to those conditions?
Mr. Matchet's not able to post any amount of bail. I know he's hoping the court releases him, but if the court doesn't do so, we'd hope that the court sets another hearing later this week.
I have concerns about Mr. Matchett's ability to abide by court orders and return. I'm gonna follow the city's recommendation and post bail in the amount of $500 each case. Bondable. Additional conditions that you attend all future court appearances, have no new criminal law violations, update your address with the court and DOL immediately if there are any changes. You still at the address on Mr. Matchet?
Yes.
Do you still receive mail at the address on?
Yes, I do.
Perfect. And no contact with SeaTac International Airport or the rental car facility except for valid travel purposes. And we can set this on for, let's do Friday. All right, thank you, sir. We'll see you back here on Friday.
Be safe, be well, sleep sweet, and much love.